And so the speakers in alphabetical order will be Raphael Cox Alomar. He's a graduate of Cornell University, received a DPhil from Oxford, where he studied as a Marshall Scholar, and is a 2004 graduate of the Harvard Law School. As a lawyer, Dr. Cox Alomar has represented clients on a wide array of dispute resolution matters. He was the Popular Democratic Party's candidate for resident commissioner of Puerto Rico in the United States Congress in the 2012 general elections, and he is the author of Revisiting the Transatlantic Triangle, the Constitutional Decolonization of the Eastern Caribbean. Andres Lopez is a graduate of Harvard and Harvard Law School. He is still seeking a refund on his tuition as a result of having been in my constitutional law class, where he insists he failed to receive fair value for his money. But I have been proud of him ever since. After his graduation from the law school, he clerked for two very distinguished federal judges, worked for a few years in large law firms, and for roughly the past 10 years, he has been running his own law firm. He served as an advisor to President Obama's 2008 and 2012 presidential campaigns, and in 2012 he served as vice chairman of the Democratic Convention's Platform Committee. Carlos Guarin Peralta received his AB degree from the College of the Holy Cross, his JD from the University of Puerto Rico Law School, and his LLM from Harvard Law School. He is a professor of law at the Inter-American University of Puerto Rico. He has been a consultant and an attorney for the Puerto Rican Independence Party since 1989, and he is the author of a number of publications on Puerto Rico-United States relations since 1979. And so without further ado, I leave it to the distinguished panel. They have insisted that they will each speak for 20 minutes. I was trying to hold them to 15, but they've told me no, they need 20. But I hope you really will observe the 20 minutes so that we'll have time for exchange and questions.
25 minutes.
Thanks.
Yeah, I want this. Just want to move it so it doesn't. There we go. All right. Well, good afternoon. It is always an honor to return to Harvard, and I want to thank Jerry and Tomiko and all those responsible for organizing this conference, which marks the first time in Harvard's history that we reconsider the insular cases. And I want to extend a special word of thanks to my great friend, Martha Minna. Martha's inspiring leadership of our alma mater gives me hope that just as Harvard played an all too prominent role in paving the way for the insular cases in the 20th century, it will be Harvard and its modern day alumni who will help eradicate their legacy in the 21st century. So it is important that this conference is taking place now at Harvard in this unique moment of crisis. And I want to thank Martha for making that happen. So in keeping with the conference theme, today's crisis provides us with an opportunity for reconsideration, literally to consider again decisions of the past and ask ourselves if we would do it the same way again. For example, if we had to do it again, would we create an inherently unequal American territory whose very structure undermines the concept of the consent of the governed, and would we hold it in seeming perpetuity? By like token, would we demean the concept of American citizenship by inventing a second category of citizens without the same constitutional rights as every other citizen? I don't think so. And so if we are to change the course of history, our goals must be clear. America cannot hold territories indefinitely. And America cannot have second-class citizens. Our goal must be equality. Now, if Puerto Rico's structural problem is its fundamental inequality, then today's crisis shows the consequences of sustained inequality. Puerto Rico's territorial status has impaired its ability to develop economically, politically, even socially. And it begs the question, were territories meant to last as territories for over 100 years? After 115 years of kicking that can, I think we know the answer. We must then step back and reconsider everything from the start. And if we're going to start at the beginning, we must begin at Harvard. It is literally...
I wasn't here at the beginning, I want you to know.
True enough. It is literally impossible to overstate Harvard's role in laying the groundwork for the insular cases. That empire-minded vision fueled by prejudice, that America could hold territories indefinitely and create a subcategory of citizens in this country. Some of that breathtaking chutzpah no doubt stems from the notion, thankfully a relic today, that only Anglo-Saxon males could be trusted with the duties of self-government. After all, this was the age of separate but equal, where women could not vote, and there was certainly no marriage equality. And of all the Harvard Law Review authors who wrote about America's new possessions at that time, none was more influential than my fellow Harvard Law alumni, Abbott Lawrence Lowell. Now, fittingly, Lowell became a government professor at Harvard in 1898, the year that the US acquired Puerto Rico. The next year, Lowell published his infamous article entitled "The Status of Our New Possessions, a Third View," which persuaded the Supreme Court to invent the unincorporated territory. Now, in fairness, Lowell later became president of Harvard, and as a student here, I did benefit from some of his reforms. But as a Puerto Rican, I, and millions like me, have been disproportionately affected by one of his greatest mistakes. Before the insular cases, the acquisition of territory meant eventual equality without exception. And the grant of American citizenship always meant equality. So before Lowell's article, the notion that Congress could hold territories indefinitely ran counter to the very principles that led to this country's existence. And yet Lowell concluded that applying the Constitution fully in the new territories would lead to an irrational result. That peculiar phrase, irrational result, becomes a little bit easier to understand after one learns of other irrational results that Lowell sought to avoid at the time. To note just one example that's well documented in Professor Ken Mack's book, Reconsidering the Race, Lowell thought it was irrational to force upon white Harvard students the alien notion of having their black counterparts live under the same roof in Harvard dorms. Now, unlike in the insular cases, Lowell's view did not carry the day. And while we have largely erased the stain of this type of insidious prejudice, the insular cases and their prejudiced rationales still stand today as remnants of a bygone era that this country has largely left behind. So in my view, the United States cannot hold territories indefinitely in an unequal state. And Puerto Rico's current crisis provides Harvard with an opportunity to say just that. Harvard should play a leading role, as it did back then, but this time to help put an end to this shameful legacy of discrimination. And as we reconsider Harvard's role in the insular cases and Puerto Rico's future, we must ask ourselves, would Harvard endorse Lowell's views today? Would it support such aberrational notions of inequality? I'm convinced it wouldn't. Lowell got it wrong in the 20th century. Harvard can get it right in the 21st century. And so that is Harvard's challenge. First, Harvard should say categorically that America cannot hold territories indefinitely. That's not America. That's not who we are. A country founded on the concept of the consent of the governed cannot keep a territory in a perpetual state of limbo. Second, Harvard should say, as Justice Margaret Marshall did in her ruling on marriage equality about a decade ago, that our Constitution forbids the creation of second-class citizens. Harvard should say, as Justice Harlan did in his insular cases dissent, that our Constitution is colorblind and neither tolerates nor knows classes among its citizens. The time has come for Harvard to vindicate Justice Marshall and Justice Harlan's views. And the time has come to consign Lowell's misguided view to the dustbin of history. Now, in my view, today's crisis also presents a unique opportunity for President Obama. I'm proud, as Dick said, to have played a role in his 2 historic elections. And with regard to Puerto Rico specifically, I'm especially proud that President Obama has changed federal policy for the better. Thanks to the work of the White House Task Force on Puerto Rico Status and the Democratic Party's Platform Committee, to which I proudly belonged, the course of action for the president's second term clearly signals an urgent need for change. Now, our policy on Puerto Rico is rooted in a trilogy of principles. First, that the failure to resolve the status problem has held Puerto Rico back, and that the time has come for Puerto Rico to take the next step in its relationship with the rest of the United States. Second, that the economic success of Puerto Rico is inextricably intertwined with a swift resolution of the status issue. And third, that the White House specifically commits to moving the status issue forward with the goal of resolving it expeditiously. These bedrock principles are timely, given today's crisis, and they point the way to a resolution of the problem. More recently, after the historic 2012 vote, where Puerto Ricans voted overwhelmingly to reject the status quo, the White House made history again by saying that the results of that vote were clear, that the people of Puerto Rico want to resolve their status, and that statehood, the people's choice for a path forward, had prevailed. Last month, President Obama signed into law a bill that, among other things, calls for a $2.5 million allocation for a process that will resolve Puerto Rico's status. And I want to acknowledge one of its original intellectual authors who served with distinction in President Clinton's term, Mr. Jeff Farrar. So the chorus for change keeps growing louder in Congress as well. Senator Wyden, Senator Heinrich, and Senate Majority Leader Harry Reid are just some of the members who have recently expressed their support for Puerto Rico equality. So President Obama has done much for Puerto Rico, but today's crisis gives him an opportunity, in my view, to do much more. He has an opportunity to fulfill a pending promise and to cement his legacy. When he became president, President Obama promised to resolve Puerto Rico's status problem during his first term in office. He made that vow most publicly in a 2009 letter to Puerto Rico. He acknowledged that prior administrations had kicked the can for years on this issue, and he said, this time must be different. Well, this time is different. For one thing, the current crisis in Puerto Rico urgently calls for a once and for all resolution to the problem. But more importantly, since the start of his second term, President Obama's administration has officially become the first administration in American history to confront a clear rejection of the status quo from the people of Puerto Rico. So now the people have spoken, the promise is pending, and our crisis is urgent. The president can help resolve it, and in so doing, he can make history. Now, President Obama also has an opportunity to cement his legacy. In his second inaugural address, the president spoke movingly about how our journey is not complete until we ensure, for example, that a little girl born in the bleakest poverty knows that she has a chance to succeed like anybody else because she is an American citizen. She is free and she is equal, not just in the eyes of God, but also in our own. I thought that was terrific. Yet I wonder if I was the only one who imagined that beautiful little girl being born in Puerto Rico and thinking to myself that if that was the case, she wouldn't have an equal chance to succeed. And so if we truly are to make these enduring and self-evident rights true for every American citizen, our journey is really not complete until we achieve full equality of citizenship for that little girl and for everyone like her. We have all seen the seismic demographic changes in the Latino community, and I firmly believe that the story of Latinos is the story of America. But the story of America cannot be one where that little girl born in the bleakest poverty knows that she does not have an equal chance to succeed because she feels the burden of a second-class citizenship and suffers the consequences of that inequality every day. The story of America cannot be one where a president can send a young man into harm's way to defend our freedoms, but that young man is not free to vote for his own commander-in-chief. The story of America cannot be one where you're good enough to die for your country, but not good enough to vote in it. And yes, the story of America cannot be one where a citizen can be good enough to raise millions of dollars to help elect a president, but not good enough to cast a single vote in a ballot box. In the story of America, no right is more central to citizenship. No right makes us more equal than the right to vote. And there's the opportunity. President Obama can become the first president in American history to cast the issue of equal citizenship for Puerto Ricans as a moral imperative. In 1963, President John F. Kennedy did something no other president, not even Lincoln, had done. He committed the country to assuring full equality for African Americans, and he declared that doing so was a moral imperative. And just last month, I heard President Obama say in the context of immigration that we do not want a situation in which we have two categories of persons in this country. And I said, that's exactly right, except that we have that now. As the president says, we should not. So the president should commit the country to assuring equal citizenship for Puerto Ricans as a moral imperative. He should say that our Constitution forbids the creation of second-class citizens. Now, if he does so, in my view, he would cement his legacy with the Puerto Rican community, who hold few things as dear as their American citizenship. And President Obama is uniquely equipped to make this case. He was born on an island, the last territory to become a state. And his own family background and history shows that he is all too aware of the soul-crushing effects of colonialism. So in light of the 2012 vote in Puerto Rico rejecting the status quo, and in light of the 2014 crisis that is deeply rooted in the legacy of the insular cases, the president has the chance to bend the moral arc of history, which we all know bends towards justice, but doesn't bend on its own. So we now have an opportunity to complete our journey. And until we resolve our structural problem, really our civil rights deficit, that has held Puerto Rico back, we will only be placing Band-Aids on the real problem. And at other difficult times in our history, some have said, let's not focus on solving our structural problem. Let's focus instead on other issues, like the economy. But as the White House has established, our economic success requires resolving our status problem. In this moment of truth, Band-Aids just won't do. So we have a fundamental choice. We can continue down our current path and say again that status is not the issue, or we can have the courage to change. The people of Puerto Rico showed enormous courage in November 2012 when they rejected the status quo and said, in essence, we want change. When Rosa Parks refused to sit in the back of that bus, she did so because she got fed up and she did something about it. Well, the 2012 vote shows that Puerto Rico is fed up. And this 2014 crisis requires us to do something about it. Now, too many times we've expected change to come from Washington, but our history shows that change works exactly the other way. Change must come to Washington, and that's what we must do. That's my cue. Thank you very much.
So thank you so much to Professor Gary Newman, Professor Fallon, and the Dean Mino and the other members of the Harvard Law faculty for actually convening such an important gathering. It's great to be back as an alumnus to discuss an issue that has always been very close to my heart and to which during my years here I devoted considerable attention, in part thanks to the generosity of great mentors such as Professors Shapiro, Singer, and the late Arthur von Mehren. As you might very well know, Puerto Rico is undergoing today an economic meltdown of epic proportions. As recent as February 4th, Standard & Poor's lowered Puerto Rico's credit rating to below investment grade or junk status. Soon, Moody's and Fitch followed suit on February 7th and February 11th, respectively. As we speak, the possibility of a Commonwealth default scenario on its $70 billion debt is a clear and present danger, due in no small measure to an absence of liquidity and overextended financial obligations. Contrary to Greece, Cyprus, Portugal, Ireland, and Spain, the Commonwealth won't be bailed out by the US Treasury and or the Federal Reserve, at least not at this stage. Hence, Puerto Rico's economic meltdown will no doubt have a ripple effect in the mainland, destabilizing both the US municipal bond market, valued at close to $4.3 trillion, and over 75% of US muni bond funds, where millions of American workers, retirees, and investors would be exposed in the case of a Puerto Rican default. From this gigantic fiscal crisis, however, comes forth a great opportunity, not just for economic restructuring, but equally importantly for political constitutional re-engineering. It is no secret, as the Federal Reserve Bank of New York, the General Accountability Office, and the White House Task Force reports on Puerto Rico's status have all come close at hinting Puerto Rico's economic crisis is a reflection of a wider and equally pervasive political meltdown. The perpetuation of a quasi-colonial relationship with Washington, one that unilaterally imposes on the island's weak economy all the regulatory costs of one of the world's strongest and most expensive economies, along with the superimposition of values of overdependency, have no doubt exacerbated the triggers behind the meltdown, making it even harder for Puerto Rico to battle an endogenous fiscal meltdown in a weakened global economy. Thus, the opportunity has arisen for addressing the economic meltdown by addressing the more than evident politico-constitutional meltdown. So, and the question is, what does the future hold for disentangling Puerto Rico's status conundrum, both procedurally and substantively? Procedurally, as things stand right now, the ball is in Puerto Rico's court. The omnibus spending bill signed by President Obama on January 17th assigns $2.5 million for voter education and a plebiscite on status options that must pass constitutional muster as certified by the U.S. Department of Justice. Thus, the Commonwealth Legislature must now decide how to engage the political branches in Washington in a manner consistent with the procedural mechanism put forward by the Obama administration in its pending omnibus bill, while also making sure that Congress sets in motion a full-blown self-determination process as soon as the status definitions are agreed upon. Meanwhile, there are two statehood bills before Congress. One in the House, presented by resident Commissioner Pedro Pierluisi on May 15, 2013, that's H.R. 2000, and another one in the Senate, that's S. 2020, presented just a few days ago, on February 12th, by Senator Heinrich from New Mexico. None of these statehood bills sets a clear path towards self-determination, as they exclude from the process the other non-colonial, non-territorial options available to the people of Puerto Rico besides statehood. In my estimation, the most sensible procedural path is to activate the Constitutional Convention mechanism as promised by the current Popular Democratic Party government during the 2012 campaign, and have the convention draft alongside the U.S. Department of Justice constitutionally viable options that must also be non-colonial and non-territorial. The inclusion of the Constitutional Convention mechanism in the procedural equation, that is, a convention made up of both political and non-political delegates, equally distributed among the existing ideological forces, would extricate the negotiating process from the vagaries of the island's tight electoral timetable, and would stand as a guarantee that even in the face of a change of local government in 2016, this self-determination exercise will run its course. In all probability, a consensus will be reached in the not-so-distant future on the procedural aspects surrounding the island's status, Gordian knot. So let's address now the more complex substantive aspects of this process. And I will not dwell on an analysis of the statehood and/or independence propositions. I will defer to my colleagues in the panel to do so. I will, however, focus on one of the most intractable substantive challenges besieging Puerto Rico's status process today, and that is the Popular Democratic Party's ideological crisis, the unwillingness of its current management to acknowledge that as a matter of U.S. public policy, the so-called enhancement formulation of the Commonwealth can only flourish outside the territorial clause. The Commonwealth camp must urgently come to grasp with this unescapable reality. Only a new relationship premised along the lines of an association model whereby the US's political branches transfer to Puerto Rico the powers of sovereignty acquired by the United States over the island under the terms of the Treaty of Paris, will enable the so-called enhancement that for too long the PDP has been pressing for. The most recent hearings convened by the Senate's Committee on Energy and Natural Resources, held on August 1st, 2013, brought to the fore in a most vivid way the unviability of the Commonwealth enhancement formulation. None of the PDP's historic claims for so-called enhancement of Commonwealth status, pursuant to which Puerto Rico would enjoy certain attributes normally associated with sovereign nations, such as deciding on the applicability of federal legislation, participating in international organizations, having authority to enter in its own right into international agreements, having the power to regulate commerce among Puerto Rico, the United States, and foreign countries, or having authority to levy, increase, or reduce tariffs and quotas. None of those powers will become available to Puerto Rico under the Commonwealth's current territorial condition or under any enhancement formulation that leaves intact the current arrangement whereby Congress retains sovereignty over Puerto Rico. Not surprisingly, all attempts, and this is essential, this is something that's essential to grasp, to realize the magnitude of the ideological decolonization that must go on within the PDP. Not surprisingly, all attempts made since the days of the Eisenhower administration at endowing the Commonwealth with further political authority, all those attempts have foundered, as shown by the outcome of the 1959 Furnos-Murray Bill, the 1975 Compact of Permanent Union, the post-1990 Office of Legal Counsel's legal opinions regarding the constitutionality or the constitutional unviability of the enhancement approach, and the political branch's disinclination to enter and the political branch's disinclination to acknowledge or to accept the legality of mutual consent clauses, as evinced in the 1994 Guam legal opinion, as well as in the 2005, 2007, and 2011 White House Task Force reports on Puerto Rico's status. Two questions arise immediately that must be taken to task. The first question that immediately arises is, why has the PDP leadership shied away from taking to task the obvious infirmities of the enhancement construct? And more importantly, the second question that immediately arises is, what is the relevance of the PDP's ideological crisis to the overall question of the future status of Puerto Rico? So those are essential questions. First of all, it's essential to note, and this is something that was touched upon perhaps indirectly in previous panels, but that's something that should be studied more fully. It's essential to note that for the most part, Puerto Rico's Commonwealth movement has always sought intellectual refuge in European notions of autonomy and dual sovereignties, available, for instance, in la Carta Autonómica de 1897, in the Statute of Westminster of 1931, in the Statute of the Dutch Kingdom of 1954, in the British West Indies Act of 1967, among other European legal instruments, notions that have been unavailable for the most part in American constitutionalism, particularly following the demise of the Indian treaty system during the Reconstruction period and the hyper-federalization of US governance in the post-civil rights movement age. The ideological posture within the Commonwealth camp, however, is swiftly changing. The obvious realities that the economic meltdown has brought to bear, together with the realization that clinging on to the territorial praxis leads nowhere, has enabled the flourishing of inter-party alliances, favoring today a compact premised on Puerto Rico's sovereignty, inter-party alliances that go beyond the confines of the PDP. And at the same time, there has been an ideological decolonization at the base of the PDP itself, a process that slowly but surely has been garnering momentum of its own. A base, I should say, that has shown itself more inclined than the party's leadership to break away from the traditional enhancement formulation, if seen in light of the almost 500,000 votes in favor of El ELA Soberano at the November 2012 local plebiscite. To the extent this ideological decolonization within and without the PDP ensues with ever more strength, the people of Puerto Rico will finally have real choices before it. In the final analysis, the principles of ordered liberty and fundamental fairness upon which this republic was founded allow no other outcome than plodding along a transparent and legitimate process of self-determination, leading once and for all to a dignified, non-colonial, non-territorial relationship between Puerto Rico and the United States. Many thanks.
Good afternoon. I also thank the organizers for the invitation to participate in this conference, and particularly in this panel, whose moderator was my professor of freedom of speech here at Harvard 30 years ago. I also thank all of you for being here after a very long day. And of course, I thank Harvard Law School for having decided to address issues that for too long have been kept, so to speak, in the closet. Judge Torruella said many years ago that the insular cases, and I quote, have been relegated to the back burner of judicial concern, and that their doctrine floats in the penumbra of legal priorities considerably below the rule against perpetuities. Reconsidering the insular cases is a welcome development. I have entitled my presentation, Puerto Rico and the United States at the Crossroads. In the singular, crossroad is a junction of one street with the other. In the plural, it is a crisis situation or point in time when a critical decision must be made. The relationship between Puerto Rico and the United States, in fact, stands at the crossroad of constitutional law and international law, particularly the international law of human rights, and more specifically, the collective right of all peoples to self-determination. I share the view that the constitutional doctrine of territorial non-incorporation is a constitutional anomaly forged out of imperialism and racism, and a mutation of the fundamental values on which this republic was erected. But I will focus on the international law that evolved during the second half of the 20th century in direct contradiction with the constitutional doctrine of the insular cases. The term self-determination, coined almost 100 years ago by none other than Woodrow Wilson and Vladimir Lenin, acquired the status of a legal right after World War II, with its basis on the UN Charter, as has been previously said, and the International Bill of Rights, that is, the Universal Declaration and the two international pacts, covenants on human rights. Article 1 of both covenants recognizes the right of all peoples to self-determination and, perhaps more important, imposes on signatory states the duty to promote and respect the right. Several UN resolutions, several decisions of the International Court of Justice evidence the formation of an international consensus regarding that right, increasingly considered an inalienable right of all peoples, even part of Jus Cogens, a peremptory norm of customary law. The United States, as has been said previously, signed and ratified the International Covenant on Civil and Political Rights. It would then follow that it is part of the supreme law of this land, as ordained by the Supremacy Clause. But the declaration made by the Senate upon its approval of the treaty states that Articles 1 through 27 are not self-executing. Of course, since 100 years ago, the doctrine of not self-executing treaties has been enthroned in the jurisprudence of this country. It has been strongly questioned with very solid arguments by several authors, including Judge Torreya, both in his scholarship and from the bench. Originally, international law, as you all know, developed as the law of nations. It defined the rights and obligations of nations vis-a-vis other nations. But now, the international law of human rights has evolved to recognize rights of individuals, groups, peoples, vis-a-vis their own governments. It should no longer be maintained that a nation may represent before the international community a commitment to recognize, respect, ensure, promote human rights, and yet refuse to recognize and respect them because the treaty is not self-executing. That argument makes a travesty of international obligations. Still, regardless of whether the judicial power of the United States abandons the doctrine or not in the near future, the right to self-determination is recognized by everyone in the international community, thus becoming a peremptory norm of international law, of customary law, binding even for states that have not signed or become state parties to a treaty. It is, since 1900, in the Paquete de Habana, part of the law of this land. Be that as it may, will Congress, should Congress, act to fulfill its legal, moral, and political obligations regarding the exercise of self-determination by the people of Puerto Rico? I think it should. I think it must. The relation between Puerto Rico and the United States stands at the crossroads. We are in a crisis situation or a point in time when a critical decision must be made. 3 reasons for that must. First, after 116 years under the plenary powers of Congress, colonialism has failed. The territory is broke. The crisis, which can be traced to more than 40 years ago, now after 7 or 8 years of recession or depression, take your pick, taints the prestige of the United States, menaces the stability of its bond market, and looms over the Treasury as some people are starting to talk of a federal bailout to save the day. Secondly, the people of Puerto Rico have rejected the territorial relationship. For 60 years, the United States and the supporters of the regime defended the legitimacy of the relationship with the consent of the people supposedly expressed in 1952 with the creation of the Estado Libre Asociado. Well, no more. In the 2012 plebiscite, as has been pointed out, a clear majority of 54% of the electorate rejected the current territorial status. Consent to colonial regime is never valid. But now, in the case of Puerto Rico, it has simply ceased to exist. The third reason for urgent action is that the international community is observing and beginning to act. In the world stage, the UN Special Committee on Decolonization has maintained the case of Puerto Rico and its permanent agenda through a series of resolutions. The one adopted last year for the first time, characterized the relation as one of political subordination rejected by the people in November of 2012. Accordingly, the resolution again calls upon the government of the United States to expedite the process that will allow the people of Puerto Rico to exercise their inalienable right to self-determination and independence. In the Latin American region, the CELAC, in English, the Community of Latin American and Caribbean States, groups all independent nations of the region. In its most recent summit held in Havana a couple of weeks ago, the member states adopted a unanimous declaration which takes note of the resolutions of the UN Decolonization Committee, commits members to work towards the eradication of colonialism from the region, and creates a working group of 4 states to elaborate proposals for the advancement of the objectives of the UN resolutions. Given this panorama, 2 questions arise. First, what are the substantive options for the future status of Puerto Rico? And secondly, what process ought to be put in place to reach a decision? There are 3 options. Of course, the current relationship or any sort of version, as Rafael Cox Alomar has just said, is out of the question. That's the problem. It can't be the solution. But there is a Estado Libre Asociado Soberano, or sovereign free associated state, which would require that Congress dispose of the territory and that a compact of free association be adopted, following the example of several insular communities of the Pacific associated with New Zealand, with the United States. Of course, none of those communities is a viable independent nation. Their populations range from 1,400 to slightly over 100,000 people, and their combined population is approximately the population of Ponce on the southern coast of Puerto Rico. But the option of free association as a transitional status to independence cannot be summarily dismissed. There is also the option of admitting Puerto Rico as a state of the Union. Proponents of statehood insist that in 2012 their option obtained 61% majority, when in fact only 45% of those who participated voted for it. That percentage was lower than that obtained in the 1993 and 1998 plebiscites, which was 46%. Proponents of statehood insist on a claim of equality for U.S. citizens residing in Puerto Rico, and try to evoke the struggle for civil rights and racial equality to appeal to liberals and moderates in the United States. However, the status of Puerto Rico is not an issue of individual civil rights. It is an issue of the collective right of the people of Puerto Rico to self-determination, an inalienable right which, as a matter of law, cannot be renounced. Statehood is irrevocable. Can the people of a territory or colony exercise their right to self-determination and permanently renounce their inalienable right to self-determination? For Congress to make a statehood offer, it must consider if a majority of 51% or even higher would suffice, if 1/4 or 1/3 or close to half of the electorate would rather opt for separate sovereignty under independence or free association. Congress should understand that nationalities cannot be suppressed and they reappear. Let's not forget the Soviet Union, Yugoslavia, more recently, Scotland this year, Catalonia, the Basque Country, and closer to home, Quebec. Finally, there's the option of independence, which, in case anybody has any doubts, is my preferred option. The option was supported by the majority of the people 70 years ago, but has dwindled over the past decades as a result of repression and dependence. And yet, it is the natural destiny of all peoples. Sometimes, critical events produce unexpected results. For example, in 1774, George Washington said, and I quote, "I am satisfied that independence is not desired by any thinking man in America." And according to the journals of the Continental Congress, some months prior to July 1776, none other than Thomas Jefferson said that a happy and permanent relation with England was desirable and that no one was interested in separating from it. Fortunately, those were not his last words. An independent Puerto Rico would be free to pursue its economic development unhindered by federal limitations. It would be free to establish productive relations with other nations, including the United States, which would certainly benefit much more from a free and prosperous Puerto Rico than from a bankrupt colony. Of course, transition to independence would require a careful but very viable economic transition, such as that already negotiated by the Independence Party with congressional leaders between 1989 and 1991. In fact, now it turns that all three substantive options for the future status of Puerto Rico will require an economic transition from the current economic crisis to conditions of self-sufficiency and sustained economic development. In compliance with the legal obligation to promote self-determination, transitional aid under independence, for instance, must be viewed not as a federal bailout, but as reparations for 116 years of colonialism and still running. With regards to the process, which is the second question, the process to solve the problem, Washington must dispose of the territory to facilitate and to promote self-determination. In San Juan, legislation should be enacted to allow the people to exercise their constituent power in order to determine the future. Several options are currently being considered. The New Progressive Party is proposing a bill in Congress, as has been said, to promote a yes-no vote on statehood all by itself. The proposal doesn't solve the problem. First, its political possibilities are as big as the abolition of the papacy by the Catholic Church. But even if it were approved, what would happen if there is no majority? Or even if there is a slim majority? Colonialism would prevail. The current status quo would prevail. There's also President Obama's, what I call President Obama's 2.5 solution. With all due respect, I think it's a miserly appropriation of $2.5 million to educate the people of Puerto Rico for some kind of plebiscite among options approved as constitutionally viable by the Attorney General. Of course, that includes one constitutionally viable option, the territorial relationship which exists today. It's been very viable since the Insular cases. It's a non-proposal, and it does not comply in its current stage even remotely with the international obligation to promote self-determination. Of course, some members of the legislative majority of the Popular Democratic Party have proposed legislation for a constitutional assembly, a status assembly, whose majority would negotiate with the US the terms of a new relationship. And the Puerto Rican Independence Party has proposed legislation to call for a status assembly based on the constituent power which resides in the people. It would be inclusive of all non-territorial options, independent, statehood, and free association, and would demand from Congress a response to all three proposals through a process of negotiation. The end result would be a plebiscite where the people may vote on options acceptable to the US with full knowledge of what each proposal really entails. What kind of free association? What conditions and concessions for statehood, if it were plausible? What would be the terms of the new relationship between Puerto Rico and the United States, between the United States and the Republic of Puerto Rico? In the next few weeks and months, these procedural proposals will be discussed, and hopefully there will be a decision to initiate the self-determination of Puerto Rico. I hope that the forces of inertia and immobility do not stall the process, because as I said before, Puerto Rico and the United States are truly at the crossroads in a situation of crisis in which a decision must be made. In closing, may Harvard contribute to the solution to this complex problem? Of course. This conference has been a good start to reconsider the Insular cases. But this cannot end today. It must be a new beginning with an ample agenda. For example, the Human Rights Program should dedicate efforts to debunk the theory of not self-executing treaties in the area of human rights. And even 115 years after the fact, Harvard should expunge an embarrassing page of its faculty scholarship after reconsidering the insular cases, it should repudiate the imperialist theories articulated in the pages of the Harvard Law Review in 1899. Those articles by Langdell, Randolph, Lowell, Thayer set the stage for the congressional exercise of imperial power and paved the way for the constitutionalization of colonialism by the Supreme Court. Harvard, as has been said before, can now point in the opposite direction. Colonialism demeans both the colonized and the colonizer. The time has come to agree with Justice Harlan when he dissented in Downs v. Bidwell in 1901. And I quote again the words read by Judge Torruella. The idea that this country may acquire territories anywhere upon the earth by conquest or treaty and hold them as mere colonies or provinces is wholly inconsistent with the spirit and genius as well as with the words of the Constitution. May I add that it is also inconsistent with the international law of human rights and an outrageous insult to human dignity in this day and age. I thank you very much.
Well, I want to thank the panelists who have us splendidly on the way to the goal of generating more light than heat that I set for this discussion at the beginning. And I think I may just ask one question before going to the audience. I hadn't known exactly what to expect coming in here, but if you separate substance from procedure, there is remarkable unanimity on one at least narrow substantive point, and that narrow substantive point is that the current relationship between Puerto Rico and the United States is, for one or another reason, untenable. So something needs to be done about it. Beyond that, there would be disagreement among the panelists about what precisely ought to be done. But that seems to me to be a significant area of agreement that moves the question of what ought to be done procedurally front and center as one worth further discussion to see whether there is in fact agreement on that point as well. And so without being an expert on these matters in any respect whatsoever, Mr. Cox Alomar has proposed what he calls as a constitutional convention of some sort, made up of you might just say a little bit more about how you think the delegates to that constitutional convention might be selected. Then we've also had the proposal for what was referred to as a status assembly by Mr. Gurin Peralta. And how is that like or unlike a constitutional convention? Is this an ordinary meeting of the Puerto Rico legislature? How would members of this, in your view, most ideally be selected? And then Andres Lopez made a number of procedural suggestions about initiating a process of change, but not one that moved that far along, so that once some movement was actually beginning to occur, how the various constituencies within Puerto Rico might get together to negotiate or to arrive at some ultimate determination, to see if there's some possibility of consensus about what ought to be done. So with that modest bit of framing, constitutional convention, status assembly, and then Andres, what do you think? Are we close to consensus on this point?
Well, as a threshold matter, I mean, in terms of semantics, when I refer to constitutional convention, I was referring to the same concept Professor Gorrin Peralta referred to, status assembly. Fundamentally, there's there is an understanding in Puerto Rico that in order to prevent confusion between the constitutional convention mechanism the Puerto Rico Constitution provides for in Article 7 of our Constitution for the exclusive purpose of amending our internal constitution, there's a wide consensus that the term of art that should be used to characterize the procedural mechanism we're advocating for should be status assembly and not constitutional convention. So basically, we're just proposing similar process whereby delegates are elected by the people. And I would suggest that the proposal put forward by former Senator Rubén Berríos is a reasonable proposal, whereby delegates are elected on an equal basis, representing the ideological forces of Puerto Rico. And you might have non-political delegates elected too. That's something that should be discussed more fully. Now, those delegates are going to have the responsibility of negotiating with the political branches in Washington the definitions of the non-colonial, non-territorial options that in the final analysis will be put to the people of Puerto Rico in a vote. Now, the proposition I made in my paper is that now that the Obama administration has at least put forward this discrete procedural mechanism, that we should engage the administration, and we should make use of this opportunity, but that rather than having the local legislature negotiate with DOJ the formulas and with the political branches, we should actually use the status assembly mechanism, because the status assembly mechanism can have a term of maturity that surpasses the tightly knit bounds of the local electoral timetable. So basically, you want to have an assembly that can negotiate with the DOJ beyond 2016. I mean, you don't want to have a change of government that's going to basically stall the process in the middle of the road. And that's why I believe the status assembly could actually be of use at this juncture.
I agree with Rafael's semantic clarification. We're drawing away from the term constitutional convention to avoid technical problems that would arise if somebody tries to challenge it because it doesn't comply with the specific requirements to call for the constitutional convention. How could it be elected? Well, political parties could nominate candidates. Independent candidates could be also nominated with a minimal support through endorsements. The idea could be to, as Rafael said, to have the three options, have equal say in the convention, or there could be mechanisms to ensure proportional representation or a minimum representation of each of the formulas, and then each of the delegations in that assembly could propose to the assembly the definition of statehood, of free associated state, and of independence, which would be included in a resolution of the assembly to demand from Congress a response to all three. Of course, it could be through negotiation with the Obama administration or its successor in the executive branch, or it could be with the Congress, with whomever. The final details of how it would be elected and how it will operate will have to be part of the negotiation. I think Professor Fallon's observation that he could see there is some common ground in our presentations, I think that's what should be focused on. And that political negotiation in the assembly, in the Legislative Assembly of Puerto Rico, should be to find those common denominators which could form a consensus in Puerto Rico, because we have been fighting among each other for too long, and meanwhile, Congress is enjoying the freedom of its plenary powers because Puerto Ricans don't agree with each other, you know. we have to go to Washington to negotiate that. And of course, this would all culminate in the plebiscite that Andres was talking about under Obama's proposal, no, to hold a federally sanctioned plebiscite, but with prior negotiation of the three alternatives, everybody would know what each alternative entails. It would not be a wish list or a bucket list, depending. It would be concrete proposals in agreement. How could Congress react to this? Well, with the sense of Congress resolution, which is not, doesn't have the force of law, but it certainly has the moral force of a sense of the Congress resolution. So I think we should work in that direction of looking for the common denominators, because Washington does not react unless there is a major crisis in its hands.
Right, and there is now a major crisis. I too am gratified that there seems to be commonality on certain points, and I want to underscore the one about the role that Harvard itself can play, because I don't think that Martha was here when I gave my, sure. No, I know she's there. She came in, but I want to make sure she listens to it. You know, so Carlos and I stand at opposite ends of the spectrum, and we hadn't talked about our respective talks, but it turned out that as substantive suggestions, some of what we ended up coalescing on was the notion that just as Harvard really was a prominent player in leading and paving the way for the insular cases, they can actually play a very positive role in sort of undoing that harm in this century under your tutelage. And I think that that is, as has been shown today, a space where you can find a lot of potential commonality leading towards something concrete in resolution. One thing I kept saying to both Rafaela and Carlos and Dick was that, you know, if what we came here to do today was to have the same old tired debate that people have been listening to for just way too long, I think that would have been a waste of time for everybody. And so, you know, you now have something that is, I think, a meaningful, tangible thing, which is what Professor Fallon was alluding to. Was it's not just that there's agreement among us that the current territorial framework has become untenable. It's that you have the power of the vote of the people, right? I mean, this was put to a vote, yes or no, black and white, and the people repudiated. So, you know, the question becomes what next? And of course, you know, my position, the White House's view is that statehood won, so I want to go in that direction, right? But, and I should say that the White House in its report frowned a little bit on the concept of a sort of less than direct mechanism as would be the Constitutional Assembly or the Status Assembly. But look, the point is we are at a point of unprecedented crisis, and it serves no purpose to disagree on nuances. We really need for this day to serve as a catalyst for change. So, you know, whatever can be thrown in there to actually get to that point, I'm all in favor of.
So I have about 17 questions I would like to ask, but I expect that that would not be popular with the audience. And so I am prepared to go immediately to that long line of questioners.
Thank you, Mr. Moderator and friends. My name is Manuel Rodriguez Orellana. I am, as I said before to one of the panelists this morning, when I was mentally unstable, I was an international law professor. After I regained my stability, I decided to join the independence movement in Puerto Rico, and I've been doing that ever since. What I meant to ask is a follow-up on a statement made by Professor Gorrin, that while we here are divided and don't really know what the terms of statehood are, or the terms of the free association, or the terms of the transition under independence, Congress is basking in its plenary powers and saying, haha, you kids go ahead and make up your minds. Well, I would like to see if, and propose, if you think Mr. Moderator, that this might be a possibility, that follow-up to this great event at Harvard would have 3 American policymakers sitting up there, each of them saying what they think should be the correct policy of the United States towards the decolonization of its territories. Instead of having us, because it makes no sense for us to vote for statehood or independence or free association unless we know what that means. And we've done enough of that already and haven't gotten anywhere. So we need to know what the American empire is thinking. And that's why we need to clarify this. What are the possibilities of Harvard using its considerable influence to get 3 solid policymakers to tell us what it is that they have in mind and see if they can get together and make up their minds.
Right. Well, you put me on the spot and you embarrass me in the sense of revealing just how low I stand in the institutional hierarchy. But there are people. Yes, yes, you are. And so I suggest that instead of standing at the microphone, you bend low and whisper into her ear, and perhaps an answer to your question will emerge. But as a constitutional law professor, one of the things I can't help observing in response to this is that an inevitable frustration of the effort to initiate dialogue and negotiation is that under the U.S. Constitution, it's very difficult to try to identify somebody who is in an institutional position to negotiate on behalf of the United States government. And if you've got a problem about an institutional timetable in Puerto Rico upset by elections in 2016, there will be elections in this country in 2016 as well. And I don't think that there is a mechanism available under the United States Constitution to designate somebody who could make commitments on behalf of what the United States would legislate running beyond 2016. Andres, you want to say something?
I mean, one of the things, and I offer this to Martha as way of a suggestion, one of the things I had in mind in formulating the idea that Harvard could play a leading role is, let's face it, and the judge said it in his keynote at lunch, those Harvard Law Review articles formulated at the turn of the 20th century really were the intellectual framework that later allowed the Supreme Court to sort of spell out what it thought, whether we agree with it or not, the insular cases. And so as a point of commencement, may I suggest that why don't we do something that is the counterpart to that in the 21st century, but now on the issue of how do we actually get to a resolution? Because obviously, Lowell and his ilk, they weren't right. And, without necessarily agreeing with everything that my friend Manuel is saying and characterizing as such, I mean, I think that the American citizens of Puerto Rico would stand to benefit by such an exercise because it wouldn't be beholden to the pattern of elections. But there was a time when a presidential election turned on this issue in 1900, and so why shouldn't it be the case again that a presidential election can have as one of its main points of discussion, is this notion that I brought in my point, like, can America hold on to territories indefinitely? Can we have a second-class citizenship in America? So that's my suggestion.
Thank you to all of you for coming here. My question is short, I promise. So aside from addressing notions of equality, and this is for you, sorry, Mr. Lopez.
Yes.
Apart from addressing notions of equality, in purely practical sense, what does the U.S. gain from adding Puerto Rico as a state? What benefits, strategic benefits, would the U.S. gain? 1. And 2, if there were any potential benefits, would these be large enough to overshadow the bureaucratic and political difficulties of adding a new state? Thank you.
I'm reminded, there was a statehood rally in D.C. not too long ago, and they sent one of these crews. I think it was Stephen Colbert, or say, and they asked somebody, he said something like, baseball and beer. That's not my answer. Look, Although baseball and beer, you know, let's face it. No, look, first of all, I think the question is, it can be answered a number of ways, but, you know, to my mind, what America is losing now in terms of its international prestige, such as it is, you know, as a nation that stands before the world as a beacon of democracy and human rights, when in its own backyard, it has a territory comprised of, you know, 3.5 million people, although check next month, the, you know, figure might be 3.4. The notion is that Puerto Rico, for those of us who, like me, believe that statehood is the way. And, you know, statehood, however you want to frame it, has been recognized now officially by the White House as having prevailed in the 2012 election. So it's a good question to ask. And it's all right, Carla, you know, I'm not going to ask you how much your guys got, but
No, we're not claiming victory yet.
I think Puerto Rico offers now and has to offer to the United States an incredibly rich tradition that will, again, make the United States actually live up to its creed as a nation that it proclaims itself to be everywhere in the world. And I forgot the second part of your question, but I want to, the bureaucratic, yeah, absolutely, it's worth all the bureaucratic. Look, you know, having a territory in limbo indefinitely is not something that anybody should be proud of 115 years after acquiring the territory. So whatever procedural hurdles have to be overcome to getting it, in my mind, it's absolutely worth it. You know, go back to the notion of, and I know Carlos may not agree, but, you know, as an American citizen, the notion of me not being able to exercise the most basic rights of that citizenship is absolutely offensive. And no bureaucratic entanglement is worth the denial of the exercise of that right.
Thank you, but if I may, so other than satisfying that notion of equality, what other economic or strategic or political benefits might the U.S. gain and might the American people gain from having Puerto Rico as a state as opposed to just having Puerto Rico as a Commonwealth?
You mean like as a territory now?
Mm-hmm.
Well, I think that, first of all, it can be a much, much greater contributor to the national economy than it is right now, because in its, what was the bonsai tree form that it is right now, it just doesn't have it has a stunted capacity for economic growth. You look at the example of Hawaii, to just take one, and what happened after it became a state. And the examples actually don't limit themselves to Hawaii, but every territory that became a state. And by the way, I like the batting average of territories that became state, right? 37 have asked, and 37 have received the answer of yes. All of them have flourished economically, and therefore were in a better position to contribute in proportion to their size to the nation's health and welfare. So that is an uninterrupted streak in terms of how Puerto Rico would be able to help the country economically. It would be, by definition, more robust as a state, and therefore would have better standing and better position to make a great economic contribution.
Okay, I want to intervene just preemptively at this point. Yes, you'll have a chance to respond. Technically, we've got about 10 minutes left. There are 6 people in the queue. I will feel very badly if anybody is shut out of the queue. We can probably go a few minutes longer. I look at Jerry Newman, and he's nodding his head yes, but I'm going to ask the panelists and the questioners, please, to be brief so that nobody gets shut out.
The question wasn't addressed to me, but Andres' answer provoked my response. We must all recall the 3 fundamental political criteria used by Congress in all 37 processes of admission of new states. One was that the people clearly want to go from territory to state. Second, that the people be imbued with the values of the American system of government. And three, that the territory have sufficient resources to support its own government and to make its contribution to the federal government. I think this is the worst time for the statehooders. Perhaps that's the reason why all 37 were very prosperous when they attained statehood, because they were going to be prosperous anyway. That's why they admitted them. Such as California.
A young man that preceded me said he had to go to class and asked if he'd go before me, and then I got put in the category of people that have to be brief, so that's really ironic. But
so you're not off to a good start being brief.
Yeah. First of all, just a correction, there are only 32 states that have been admitted from territories. 5 were admitted, and of the 5 that were admitted, West Virginia and Vermont and whatnot, there were questions about whether they were viable for states at the time. But anyway, I don't want to get involved.
Still 100% batting average, right? I'm right about that.
I do want to say, I was a Peace Corps volunteer in Micronesia at the time. It was a United Nations trusteeship. And my wife is from the island of Koshrai in the Federated States of Micronesia, and our kids were born out there on the island. And I went on to work at the White House during the Reagan administration, and was part of the process for getting the Compact of Free Association for Micronesia. And I was one of the people who sold, on behalf of the Reagan administration, the Compact of Free Association for Micronesia to the United States Congress. At a time, the United States Congress was very skeptical. And I can tell you this, that was the last time that the United States has changed the status of a territory that was under its governance. Time before that was Alaska and Hawaii in 1959. So in 1986, when we did that for Micronesia, that's the last time it's been done. And since there are time constraints here, I would just like to make one statement and then ask a question. First of all, I want to make one comment, and it is that the professor that spoke in the last panel said that self-determination is a process, not an event. And the fact of the matter is that, like it or not, imperfect as the process was, the insular case has deconstructed the Northwest Ordinance model, and what we're really talking about is what Mr. Lopez said, which we now have to reconstruct the process. And the fact of the matter is, imperfect or not, you did ratify a constitution in Puerto Rico through a democratic process of self-determination about the form of constitutional government. At the same time, they should have had an act of self-determination about status and citizenship, and so we're trying to reconstruct what was deconstructed. Now, that constitutional government that was ratified in 1952, it has now, through its constitutional process, promulgated laws pursuant to which there has been a vote. And the vote is part of the process of self-determination. And so now what I'm hearing is that, well, let's now have a status assembly. And so, if you're going to have a status assembly, the way to have a status assembly is to have the legislature of Puerto Rico pass a law creating a status assembly. And so, the only thing I'd say about that, and then I'm going to ask a question. I'm going to shut up and then ask the question.
Either finish your statement or ask a question, but we don't have time for both.
I lost my train of thought now. The point is, first of all, my understanding of the Obama, and it's hard for me from the Republican administration, but I got to tell you, I think the Obama administration has created a viable process here to move forward. My understanding is that the 3 parties would get, and the State Election Commission would get to negotiate with the Obama administration and the Attorney General, and so the collaborative process that you guys are talking about is one I think that would go forward. So my question is this. First of all, to Mr. Cox Alomar.
So let's let somebody else have a chance. It's a very interesting statement, but I don't think we're going to have time for responses. So if you'd let somebody else have an opportunity, I'd be grateful.
You're not going to let me ask my question? Okay.
Okay. Sorry.
I have 2 comments that I'll self-censor and go directly to my question. And the question is this. I haven't heard very much talk, and perhaps the folks who've been talking about the Status Assembly or Puerto Rico know more. I haven't heard much talk about what variations of statehood there would be. What I mean by this is, in the history of the 34 territories that were admitted as states, you have conditions about slavery, about English language, about land being set aside for capitals, schools, prisons, and all sorts of other variations within the continental North America. And so I'm wondering, is there talk about if there are statehood, but the statehood is really just that federal representation and that financial autonomy, then what about beyond that into conditions about admittance to the Union?
Very briefly, there have been conditions placed in the past to states that are admitted into the Union, and once they do become states, some have been felt free to disregard them, and others have complied with them. Oklahoma famously being told where to place its state capital, and upon admission, they decided they were going to place it where they liked it. Thank you very much.
Hi, my name is Laura Rodriguez. I'm a third-year law student from Puerto Rico. I have two very brief questions. The first one is to you, Mr. Lopez. You've spoken of equal citizenship in various occasions. It seems as if the Obama administration favors statehood, but equal citizenship isn't the same as equal rights, and us Puerto Ricans lack more than just equal citizenship. You've also said that the status change depends on Puerto Ricans, but time and time again, that has been said and the government hasn't complied. What needs to happen for the government to act upon its promise for status change? As a Puerto Rican, I haven't seen any of the actions you described the Obama administration has done for Puerto Rico.
Well, okay, let me start with that last one. Because those are factual. I mean, I was just literally, reading from things that they have actually either produced or part of their platform. But your point is well taken. I mean, look, in the fight for equality, I do take your point that it's not just about equal citizenship. It's about a larger panoply of equal rights. There's no template for what gets you to statehood. A number of different.
I'm sorry to interrupt you. So it's Obama administration is pro-statehood?
No, I mean I'd love them if they were, but they're not anti-statehood. I think that they have said, the president has said in 2008 when he was in Puerto Rico in May 2008 that if the people voted for it, he would.
So what would it be then? Would it be the enhanced Commonwealth that Puerto Rico's governor has spoken of?
No, I think they've been, actually, if anything, I think that on the enhanced Commonwealth option, they have been clear in saying that that is not viable under constitutional law, which actually is one of the greatest contributions, because a lot of people, I think, wondered whether they would follow the course set in prior administrations or depart from it, and I think they laid out very clearly in the report.
I'm sorry, then I don't really understand what is it that the Obama administration wants for Puerto Rico, because it's not statehood, it's not an enhanced Commonwealth, and it clearly is an independence.
So they want to move the process forward with the goal of resolving it expeditiously without weighing, towards any one of the particular options. So that's actually the best role that they could play, in my opinion, not necessarily leaning in favor of one or the other. But look, I mean, I'd be thrilled if, as a matter of policy, as I said in my speech, the president said that, as Kennedy did in '63, that achieving full equality of citizenship for Puerto Ricans was a moral imperative. Personally, I would like that. As a matter of policy, the administration has committed itself, both in the platform and in the report, to resolving the issue expeditiously. I think our task is to make sure that that doesn't just become an empty commitment, but that the process moves forward to an actual resolution.
Thank you.
Yep.
Let me just note that the new law provides a process, as Howard mentioned. The State Elections Commission makes a proposal and virtually negotiates, and the Elections Commission includes representation from all three parties in Puerto Rico. That doesn't mean that the process can't be enhanced in some way. Either has been proposed in Congress or proposed by others, including the PIP. I'd like to compliment the panel, all three, and ask Rafael in particular, and compliment your statements as well. What is the problem within your party that the party isn't moving forward for the autonomy that the party has always aspired towards?
Well, I think it's no secret. I mean, there's a tug of war. I mean, there's an ideological conflict of sorts. That's a natural conflict. a conflict that has been recurrent throughout history. I mean, the same conflict Valdoriotti faced in the late 19th century against el Partido Liberal Reformista and those who wanted to have a mere administrative autonomy from Spain vis-a-vis those who wanted to basically superimpose the Canadian dominion model on Puerto Rico. So the same thing is happening right now, with the fundamental distinction that I believe the base of the PDP has undergone a process of ideological decolonization that I had described in my paper. I mean, people who believe that the evolution of the Commonwealth formula must be drawn without the territorial clause. I mean, outside the territorial clause, are gaining ever more influence and sway within the party. I mean, but then the management of the party, the current president of the party obviously has been rather shy at facing this inescapable reality. And in the next few years, perhaps you'll see new leadership with new ideas.
Thank you.
Hi. As I stated earlier, since Truman in 1933 until now to Obama, all presidents have publicly said that they approve any decision that the Puerto Rican people make in terms of self-determination. My question is, does the Congress really believe that the people of Puerto Rico right now have a right to self-determination? And my question goes because I think it was in 1995, Jose Serrano made a project in Congress so that the Congress would recognize that the people of Puerto Rico had a right to self-determination. It didn't make it to the floor. And in general, I think there are three factors that affect the present problem. Number one, the amount of federal funds, because the amount of federal funds is a way to create a dependency between Puerto Rico and the United States. What's the problem? My problem is how the Congress can recognize the right to self-determination of people that always are in Congress begging. O sea, how the Congress will recognize the right to self-determination of politicians that are always begging for money. O sea, the absence of congressional direction on resolving the political problem and the clear majority. My question is, does the Congress recognize directly the right of the people of Puerto Rico for self-determination? Because the presidents do, inclusive, there are three presidents in the history that publicly said that they want statehood, and that are Reagan, Bush, and Ford. Inclusive Bush in the executive branch said to all
the executive department.
Bush said to all the branches to treat Puerto Rico like it was a part of the Union. So my question is, does the Congress recognize the right to self-determination of the people of Puerto Rico?
Well, I think that it's essential to note and go to the historical record. I mean, empires do not act. They don't have a sense of urgency unless there's a crisis. I mean, if there hasn't been a crisis in Algeria, de Gaulle wouldn't have pushed for the decolonization of the Francophone Africa. If the Third Reich had basically demolished London, the British wouldn't have pushed for Indian independence eventually, and Gandhi wouldn't have gotten his way. I mean, and the same thing with the Dutch and with the other empires. I mean, Puerto Rico, like George Torruella mentioned in his impassioned keynote speech, I mean, must actually create a crisis. Mm-hmm. We're in the midst of a crisis, but we need to persuade, and we need to push, and we need to engage Washington to realize that the Puerto Rican crisis is going to enmesh them as well. Don't you think that if Puerto Rico ends up in the next few weeks or months defaulting on its debt, wouldn't that have an immense impact on the financial reality of the United States? Isn't that obvious to the Treasury Department and the Federal Reserve? I mean, that's a type of crisis that I believe will generate a great opportunity for Puerto Rico. So we are at the verge of one of those transformational moments in the history of our relationship with the United States.
Yeah, I agree. I think that if there's something that comes out of today is that this is a moment of opportunity, and we can use the crisis to do what we've done in the past, or we can actually do it to push this issue forward to a resolution.
As I said, we're at the crossroads, in the plural.
So, Jerry, how much time do we have?
Oh, I just wanted to say that I'm from the United States Virgin Islands. My father was an American agronomist. My mother's family was from the Virgin Islands before the transfer. And that I favor free association for the United States Virgin Islands. Thanks.
Okay, so if that was the statement, I know there was a gentleman who was very eager to ask a question. Can you ask it succinctly?
I just wanted to, one, ask the representative from the Independence Party if there's a process that goes forward in the next months and there's a vote that's conducted in accordance with the constitutional process, and the vote is 50% plus one for statehood, will the Independence Party respect that result? That's my first question. Second of all, to Mr. Cox-Alamar, who gave the most intellectually honest explanation of the autonomy movement that I've heard in the 25 years that I've been involved in this issue. And I commend him for that, but I'd like to ask him, based on my experience, I believe this. It's not a question of sovereignty, it's a question of citizenship. If you want the sovereignty, you don't get the citizenship. If you want the citizenship, you don't get the separate national sovereignty. I believe, based on my experience in the White House, that that is what it comes down to. So I'd like you to just comment on that.
Of course not. Independence is an inalienable right of all peoples, regardless of whether they are submitted to colonialism or whether they are forced to join some other nation which is not their own. We will keep fighting for independence. Now the question that has to go to the Congress, is it willing to consider statehood for Puerto Rico with a 51% majority, or a 55% majority, or a 60% majority, or a 66% majority, if there is 1/3 or 1/4 or 1/2, close to 1/2 of the people who do not want to be a part of the United States because they consider themselves a separate people with the right to ongoing self-determination against, of course, the constitutional reign of this country, which was forged in the battlefields of the Civil War. We don't care about that. That's the constitutional problem of the United States. Is it willing to admit, as a state, a different nation? American constitutionalism was not designed for a multinational society. It was designed for a pluribus unum, not many, but one.
I appreciate the citizenship question because I think allows me to bring to the fore one of the fundamental, I believe, myths or obstacles in the process. I mean, the whole idea that what Puerto Rico needs is to cling on to US citizenship, and that's gonna solve all our challenges and difficulties. That's a misplaced myth to start. Second of all, the citizenship of those Puerto Ricans who already have it, it's a proprietary right. I mean, cannot be taken away. I mean, that's something that's constitutionally, I believe, self-evident. The crux of the matter is the citizenship of the unborn. I mean, the prospective citizenship of those Puerto Ricans who haven't been born yet. I mean, as a matter of US public policy, that's something that the political branches and the people of Puerto Rico need to negotiate. Superimposing, however, the Micronesian model on the Puerto Rican scenario is misplaced. the Micronesian inhabitants were never US citizens. I mean, they never engaged in a US citizenship relationship with Washington, different from the Puerto Rican people. So that's an outstanding issue that must be dealt with, paying attention to the complexities embedded in it. There are several routes pursuant to which the United States and Puerto Rico could plot along. There's the dual citizenship route, there's the free transit route used, for instance, in the case of the Micronesian Islands and also used in the case of the Philippines post-1946. The United States does have dual citizenship arrangement with a host of countries around the world. And the United States needs to speak up clear. Do they want a petition of statehood at this time and age? A petition that they are really unwilling to entertain and that really runs counter to their economic interests? Or are they willing to negotiate a truly dignified compact of association with Puerto Rico that takes into account the legal and sociological realities of a very complex and unique relationship, in the words of the US Supreme Court? So those are issues that obviously need to be addressed. Many countries around the world currently address those issues, like Holland in its relationship with Curaçao, Aruba, and the likes. Even the relationship between Greenland and Denmark and other relationships, New Zealand and former West Samoa. I mean, there are wide range of global examples. Obviously, the United States hadn't been faced with this issue before in the context of a jurisdiction where its inhabitants already have US citizenship, like is the case here in Puerto Rico. So that's a question that should not impede talking out openly about the need, first and foremost, for transferring sovereignty over to the people of Puerto Rico.
So it's my happy duty here to thank the panel and to thank the audience for what I think was a terrific set of presentations. And it is now my happy duty to cede the floor to Professor Newman.
Thank you. I think it's more important that you hear from the panelists than that you hear from me. I will not subject you to a lot of ritual, but I do have to end a long day with thanks. Thanks to the Dean, thanks to the organizations that sponsored, thanks to the audience for being here, thanks to Judge Torrea for his wonderful keynote speech, and this is a conversation which must continue. Thank you.